When is a seller actually exempt from doing a transfer disclosure statement, a TDS? Now, I'll tell you exactly when a seller is exempt because there's confusion around this topic. Many sellers might be under the impression they're exempt, but they're not, especially landlords. Those are some of the biggest offenders. And I'll explain when a seller is actually exempt. We'll start by looking at the exempt seller disclosure because this is the one-page disclosure form that agents give their exempt sellers, their truly exempt sellers. And it's a one-page disclosure, car form ESD. The thing is, this form, like the seller property questionnaire, the SPQ, this is actually a made-up form. This is a made-up car form. Unlike the TDS, which is actually a statutory legal requirement, the TDS is actually in California Civil Code. These are made up, and the idea is that it's good measure. The idea is that the more a seller discloses, the better, and if the seller is exempt, well, hey, have them do just a little bit because a little is better than nothing. And that may just help prevent some sort of legal issue from arising. So this is more of a brokerage requirement. We actually require this form for exempt sellers. But let's talk about which sellers are actually truly exempt from doing a TDS. I'm going to jump over here. This is a packet of information from the Department of Real Estate. And here we are looking at a transfer disclosure statement. And the reason why this looks so familiar to the TDS that we all do, car form TDS, is because the car form TDS is just a copy and paste from California Civil Code. It's a copy and paste of this legal template that's required by state law for residential property sellers of 1 to 4 units. But let's get to the actual list of who is exempt. Because sometimes agents think that their seller's exempt and the seller's not exempt. Or I might get a call from a listing agent and the listing agent says, my seller called me up and they're insisting they're exempt. I sent them a TDS, often it's a landlord, and the seller will call the listing agent and say, I can't do this. I've never even set foot in this rental. How on earth could I do a TDS? Well, you have to do it. You're legally required to do it, okay? And you should explain to those sellers that it's not a matter of whether, so it's asking whether you're aware. Even if you set foot or not is irrelevant. You must do it. But let me tell you exactly who is exempt. Okay, here is the list of exempt sellers. Number 1, the sale of new homes, and that is new construction, builders. Think about the new home development communities, all right? So new construction, exempt, all right? Foreclosure sales, legal process of foreclosure, to seize an asset as collateral, trustee sale, courthouse steps, that sort of thing is exempt. Court-ordered transfers. There's a court hearing. Judge makes an order. That real estate should go to that person, right? Well, the former owner of the real estate doesn't have to give the recipient through the court order a TDS, all right? They're exempt. But those are rare cases. I mean, new home builders, they have their own contract. I mean, these aren't things you come across. Here's where people get in trouble. This is a big one, probably the biggest in this list. Transfers by a fiduciary in the administration of a decedent's estate. Okay, someone passes away. You have the deceased, all right? A guardianship, conservatorship, basically a fiduciary, someone tasked with liquidating the deceased estate. Someone passes away, someone has to step in, they're selling the property for the person that passed away. They're not required. But this should actually be split in two because that's not even the big problem. Here's the big problem. Or a trust, except where the trustee is a former owner of the property. So a trust is exempt, but if the trustee is a former owner of the property, they're not exempt. And that's the big one because so many people hold their home in a living trust or a revocable trust. It's very common to hold title to your house in a trust. And those people often think that they're not required. Now, if it's held in a trust and someone passes away and the trustee is selling a property and was never the owner, never owned the property, never lived there, had nothing to do with it, all right? They just inherited the property in the trust and they're selling it, they're exempt. But for all the people that that put their property in a living trust or revocable trust and they're selling it, they're not exempt. They must do a TDS. All right, we move on. Transfers to a spouse or to a person or persons in the lineal line of consanguinity. All right, so basically you're transferring it to your spouse or your descendant, your child, your grandchild. Transfers resulting in a judgment of dissolution of marriage, okay, divorce. Transfers from one co-owner to another, okay, two friends buy a property, one person wants out, the other person takes over, no TDS requirement. Transfers by the state controller. Transfers resulting from failure to pay taxes, all right? Tax deed, county tax deed sale, that sort of thing. Transfers to or from any governmental entity. That's it. That's the end of the list. Did you hear anything about landlords in this list? No, because they are not exempt. You have here the list, and probably the biggest confusion comes between the whole trust. Now, if you have questions about this trust section, leave a comment. I'm happy to answer. But just again, to close out this video, a trust is exempt unless the trustee owned the property. They bought the property, they live in the property, or they bought the property and then they put the property in a trust and now they're selling it. They're not exempt. And that's largely the case with owners that have their property in a living or revocable trust. If you have any questions, please leave a comment and I will be happy to answer. I hope you found this video helpful. Thanks for watching.